Hello, everybody. My name is Carol Nunez Valencia, and I'm a staff attorney here with the Family Law Unit at Coast to Coast Legal Aid of South Florida. I have the pleasure today of introducing our speaker for their Family Law Clinics Legal Learning, Hanit Simon. Ms. Simon is a local attorney that represents individuals throughout the state of Florida in all family matters. Today, I am excited to introduce her. Ms. Simon began her legal career as a prosecutor for the State Attorney's Office in Miami-Dade County, where she was awarded the Spirit Award for outstanding courtroom performance. She went on to practice in civil litigation with a focus on business and real estate, but returned to family law after having the privilege of representing military service members and veterans for the United Way of Broward County. She brought her strong litigation skills, diverse legal experiences, and dedication to her clients into private practice, where she has been a zealous advocate for over a decade. Ms. Simons remains fiercely committed to improving the lives of individuals and their families in family law matters. Today, Ms. Simon will talk to us about filing for permission to relocate with your children in custody cases. We thank her so much for her taking her time today to discuss this important topic. And now I pass over the bucket to Ms. Simon.
Thank you so much, Carol. Thank you for that wonderful introduction. And I'm happy to be here to speak on relocation. I've prepared some slides, so I'm going to bring those up to share with you. Okay, so we're here to discuss relocation under the Florida Statute 61.13001. Okay, so this is a special, very technical statute, and I'm going to go through it in detail here. In Florida, a parent seeking to relocate more than 50 miles away from their current residence established by a court order must file a relocation action or enter into a written agreement with the other parent and any other person with custodial and timesharing rights to the child. This statute was last revised on October 1st, 2009, and I mention that in case somebody is either representing themselves or is represented by an attorney, to make sure that you have the current version and that you're looking at case law if you're considering cases where relocation has been considered and it applies to the revised statute. So here we go. Let's start with a definition. So under the first section, there's a definition of relocation. And again, this is a very technical statute. So we're going to go through this definition and discuss in detail the meaning of some of these terms. So relocation means a change in the location of the principal residence of a parent or the other person from his or her principal place of residence at the time of the last order, establishing or modifying timesharing, or at the time of filing the pending action to establish or modify timesharing. The change of location must be at least 50 miles. That's important. So I put it in yellow from that residence for at least 60 consecutive days. Again, another important point. So I've highlighted that for you in yellow as well. Not including any temporary absence from the principal residence for purposes of vacation, education, or the provision of health care for the child. So here we look at a definition of relocation, and it's important to know that it's comparative. So you're going to look at the residence from the time that you last had an order establishing or modifying timesharing, or the time of filing a pending action to establish or modify timesharing. And the location must be at least 50 miles away from that residence. So we're going to calculate that in a special manner. It's also intended not to apply to temporary moves. We're really looking at a relocation that has longer than a 60-day stay, and it's not just for a temporary purpose there that it's discussed in the definition. Now, if you're looking to, if you're active duty military and you're looking to be deployed, understand that there is a different statute that may apply to you. So I've put that down there in the note on the PowerPoint. If you want, look at 61.703 to 773. Those statutes may apply to active duty military who are looking to deploy with or without a child. So that may present a different situation than what we have in relocation here. So we discussed 50 miles. 50 miles is important, but it's not just going onto Google Maps or some other map application and saying, what's the difference between these 2 points? We actually use an old style of measurement called as the crow flies. Okay, so I put a little picture of a crow there for anybody to see that this is a totally different type of measurement. And there is a way of using this measurement on Google Maps. So I put down a little description here that you can take the measuring tool on Google Maps to draw a straight line between the 2 points. So you're really looking at this from above, just like the bird, and you're not looking at the actual distance on the roads. So when you're measuring a distance to see whether or not you're looking to move more than 50 miles, please use the proper measurement system as the crow flies. Okay. The next thing we want to discuss here is relocation by agreement. The courts are very clear that if the parents or any other person entitled to access or time sharing with the child agree to the relocation, they can do so by entering into a written agreement that's signed and meets these requirements. It consents to the relocation. It defines an access or time sharing schedule for the non-relocating parent and any other person who's entitled to access or time sharing, and describes, if necessary, any transportation arrangements related to that move. So it's a lot easier, as you might imagine, to relocate by agreement, but you have to make sure that you meet the requirements here with the written signed statement containing all of these terms. And if there is an existing cause of action, judgment, or decree of record pertaining to the child's residence or time sharing schedule, the parties are required to still seek a ratification of that agreement by court order. There may or may not be required to have a hearing, and the statute speaks to that. But if there is no hearing required or requested here, then it's presumed that relocation is in the best interest of the child, and the court may ratify the agreement without a hearing. So that is relocation by agreement. The next type of relocation, I would say, is where it's not agreed. If the parties or anybody entitled to access or time sharing with the child is not in agreement to the proposed relocation, then the person intending to relocate must file a petition to relocate, serve it on the other parent and any other person entitled to access or time sharing with the child. If there's an existing case, it can be done in the existing case. The petition is very specific as to what it must include by statute. So I've included a list here. It has to be signed under oath or affirmation. It has to provide a description of the new location, including a mailing address for the intended relocation, a new home telephone number. Sometimes people keep their same cell phone number, which is probably fine. The date for the intended move, a detailed statement of reasons for relocation. If it's related to a new job offer, then a written offer must be attached to the petition to relocate. The proposal for post-relocation schedule for access and time sharing for the non-relocating parent must also be attached, unless in some cases there may be an order limiting, restricting, or terminating the time sharing. So it's very important that you comply with all of the requirements when filing a petition to relocate, including here, number 7, I call this the magic statement, and I'll show you in the next slide what that entails. Here is a very specific statement that has to be included in your petition to relocate. If not, and all these other points that we made, 1 through 7, were not included, your petition it may fail. So it's very important. I put this entire statement here in yellow. It doesn't need to be in yellow when you're filing a petition to relocate. However, you have to include verbatim, word for word, this exact language that's listed here in the slide. And you can find it in the Florida Statute 61.13001, Section 3A7. So be sure to copy that exactly right in your petition to relocate prior to filing, and make sure it's big, it's bold, it's in all caps, okay? Otherwise, like I said, you may have issues, and we'll get to that. So the petition to relocate must be served on the other party with proper service of process under chapters 48 or 49. Or it may go by a court rule in the pending action if there's already service. For instance, if you happen to already be in the middle of a divorce action, a paternity action, or some other type of case, then you may be able to follow the rules related to service that are already ongoing. But in a new action for relocation, you must file it. It must be served on the other party. Okay. The statute says here you have a continuing duty to provide current or updated information as it becomes known. And once the petition to relocate has been filed and 20 days has passed, and that all those conditions that we discussed were present and put into the petition for relocate, it goes to the other party to file a response. Now, there's a provision here, which again is very important, and that's why I'm speaking to this statute with all these technicalities, because if the other party fails to timely file an objection to that petition, it's presumed that relocation is in the best interest of the child, and the court shall, absent good cause, enter an order adopting the access and timesharing schedule and transportation on an expedited basis. So there are very few statutes that pass through like this, and this is one of them. So you really need to pay close attention here to any petition, once it's been served, and the time frame for you to respond in order to make a timely objection. Otherwise, the other party may receive the green light, so to speak, and be able to go ahead and relocate. So continuing on in this section on the petition to relocate, if you do not meet those requirements that we spoke about earlier, then your petition to relocate, may not be good. And if you do, in fact, relocate without meeting those requirements, you could potentially end up in a situation where the other side may move for contempt for an improper relocation, move for a court order demanding the return of the child. And not only that, but any relocation that's improper can be taken into consideration in any action to determine or modify a parenting plan. So that could be a later factor in determining relocation. It could be a factor in determining whether a parenting plan should be modified. It can be determined as a basis for ordering a temporary or permanent return of a child. It can cause an order for a party to pay reasonable expenses and attorney fees incurred by the objecting party to the relocation. And it can result in the award of attorney fees and costs, including travel expenses. So take a look at that letter E 1 through 5 in the statute, because these are the consequences to relocating and not doing so properly. Okay, and that brings us to part 5, objection. So an answer objecting to a proposed relocation must be verified, must be signed, must include a specific factual basis supporting the reasons for seeking a prohibition of the relocation, including a statement of the amount of participation or involvement the objecting party currently has or has had in the life of the child. Okay, we discussed how important that objection is, and that it be made timely Otherwise, there is that presumption that relocation is in the best interest of the child, and the court can go ahead, absent an objection, and order relocation. So here we have the statute that speaks to temporary orders. So in Part 6, the court can deny temporary relocation or order return of the child if, as we said earlier, the petition is not in compliance, or relocation occurred without the consent or approval of the court, or the standard here, at a preliminary hearing, there's a likelihood that upon final hearing, the court will not approve the relocation of the child. So this is an interesting standard where the court has to consider at a preliminary hearing, and usually this is an evidentiary hearing where you present a request to the court to be able to relocate on a temporary basis, and the court has to make an early determination. What is the likelihood that it would grant a final relocation? Again, sort of a strange standard here, but this is the court weighing the initial evidence and making a determination. Usually these are very time-sensitive concerns, especially if someone has a job offer on the table or is beginning to make arrangements to move. So the court has to balance out the interests here, and it takes into account whether or not it's likely to approve a final relocation when it's considering the temporary order. Now, a court can grant temporary relocation pending final hearing if, again, the petition has to comply, and the court finds that there's a likelihood that upon a final hearing, the court will approve the relocation of the child. Okay, so the law tells us that there's no presumption. So we don't have a position when we walk into the room where the court does not take a position. It has to consider factors here under 61.13001, Section 7, and there's factors listed A through K. So it's very important that if you are preparing a petition to relocate, that you consider these factors in advance, not at the time of a hearing. So you would really want to take a look at all of these factors as you're drafting your petition and really speak to each one of these and how your proposed relocation falls in line with the factors for the court to consider if you're moving to relocate, or if you're objecting to the relocation. Again, look at these factors and determine whether or not you think that these are met by the petition. So the first one here is the nature, quality, extent of involvement, and duration of the child's relationship with a parent or other person proposing to relocate. All right, just give me one moment. I have to move the screen. Relocate with a child and with the non-relocating parent, other persons, siblings, half-lived siblings, and other significant persons in the child's life. So this is very important, and I'm assuming that may be why it's the first factor here that's listed. So you really want to look at this, and if you're looking to relocate and the other parent really hasn't had much involvement in the child's life, and this is something here that you want to speak to. If they have had a lot of involvement, this is a very important factor to consider and address, and we'll speak to that a little bit more detail. The next factor here, we look at the age and developmental stage of the child, the needs of the child, and the likely impact the relocation will have on the child's physical, educational, and emotional development, taking into consideration any special needs of the child. So here, there are different ages and stages that children may go through. They have different needs, and every case is unique as every individual child. And so you really want to weigh the situation as it pertains to the child or children of this situation and how old they are. There are psychologists who may also weigh in on this type of a factor here, who may be able to tell you what children need at different ages, especially if there are any special needs. Moving older children may have a much greater impact, perhaps, than younger children. So these are things that you want to take into consideration. And if you can, speak to a professional therapist or psychologist or somebody who specializes in children's issues to see how that may have an impact. The next factor here is the feasibility of preserving the relationship between the non-relocating parent and the other person and the child through substitute arrangements that take into consideration the logistics of contact, access, and timesharing, as well as the financial circumstances of the parties, whether those factors are sufficient to foster a continuing meaningful relationship with the child and the non-relocating parent or other person, and the likelihood of compliance with the substitute arrangements by the relocating parent or other person once he or she is out of the jurisdiction of the court. So again, you're going to attach a proposed parenting plan, a long distance parenting plan, most likely, so that you can set out a schedule that hopefully helps to preserve that relationship. That's really, if you're looking to relocate, that's really important here, that you present that long distance parenting plan that shows the court, not just in words, but in actual scheduling, how this would work, what does this look like, how do you maintain that relationship for the child and the non-relocating person. If you have an older child, you can take into account the child's preference, considering the age and maturity of the child. So again, you may want to speak with a professional therapist to see how that might, play out there and the child's preference. This is an important factor here, whether the relocation will enhance the general quality of life for both the parent and the other person seeking the relocation and the child, including but not limited to financial or emotional benefits or educational opportunities. So it's really important here that you're looking at this not just from the parent's perspective. So if you're a parent and you're looking to relocate because you want to take on a wonderful new job in a totally different state, that's great. But if your child is maybe perhaps 17 years old, soon to be turning 18 and hopefully emancipating soon, does it really enhance the quality of that child's life to remove them from the area where their non-relocating parent is so that you can take this job offer just before they turn 18? I mean, most of the time, you really want to show, yes, it's a better quality of life for you as the parent, but also the child. So you always want to be acting in the best interest of the child. And you want to take into account how that helps the child. Again, things like moving for higher education, that may be a great opportunity for a parent. But if the child would turn 18 prior to the parent really finishing up this program, then does it really benefit the child? So these are things you want to take into account. Another factor here in letter F, the reasons each parent or other person is seeking or opposing the relocation. So that's being taken into consideration here in the factors. The current employment and economic circumstances of each parent or other person, and whether the proposed relocation is necessary to improve the economic circumstances of the parent or other person seeking relocation of the child. So we spoke about the job offer, which has to be attached to a petition. And here we're specifically taking into account that employment or economic circumstance in those factors. Even if you're looking to relocate and it's not related to a job opportunity, you still have to take into account the economics. So just keep that factor in mind. The relocation is being sought in good faith and the extent to which the objecting parent has fulfilled his or her financial obligations to the parent or other person seeking relocation, including child support, spousal support, and marital property and marital debt obligations. So here we want to make sure that the parent who's objecting is acting in good faith and in good standing with their support obligations. Next, we look at the career and other opportunities available to the objecting parent or other person if the relocation occurs. In J, we look to see, is there a history of substance abuse or domestic violence as defined in 741.28, or which meets the criteria of 39.8061D. by either parent, including a consideration of the severity of such conduct and the failures or success of any attempt at rehabilitation. So that's an important factor here that we definitely want to look to the history, and the court wants to consider that very seriously before agreeing to allow a parent to relocate or looking at an objection to a relocation, which may leave the child majority of the time in Florida. If a parent has a substance abuse or domestic violence history, that's a strong consideration for this court to take into account. And the last factor is really any other factor affecting the best interest of the child or set forth in 61.13. So if some of your reasons for relocating or objecting to the relocation are not set out here, you can always cite to letter K, the any other factor. And at the end of the day, it is the best interest of the child standard. Okay. So here we have section 8, the burden of proof. So if you are wishing to relocate, you do have the burden of proving by a preponderance of the evidence that relocation is in the best interest of the child. If that burden of proof is met, then the burden shifts to the non-relocating parent or other person to show by a preponderance of evidence that the proposed relocation is not in the best interest of the child. So keep in mind the burdens here and the shifting of burdens if that were to happen to the objecting parent. Okay, so here in section 9, the court has discretion over what to put in the order related to the contact with the non-relocating party. So the court can look to how do we maintain access and what is the new time-sharing schedule? How is the child going to have phone, internet, or webcam type communication with the non-relocating parent? If it's financially affordable and of course in the best interest of the child. The court has to, it says in the statute, the court shall specify transportation costs that are to be allocated between parties and may adjust the child support award taking into consideration the transportation costs in keeping with the Florida child support guidelines. And you can find those under the Florida statute section 61.30. So it's really important here, again, if at the outset, prior to filing a petition for relocation, I would really strongly consider the transportation costs. Usually those are spelled out in a long distance parenting plan. And you want to consider how that may affect the child support going forward. That may need to be recalculated and it may need to be adjusted. And the court is permitted to take transportation costs into account when reallocating the child support. Okay, so again, this is a very technical statute and it offers priority for hearings or trials. So oftentimes when people are looking to move or accept a new job offer, they have to do so pretty quickly. They have a very short time frame in which to let the potential new employer know whether or not they can go. And the court doesn't want to hold people up in these circumstances. So it's looking to make, give priority to these types of petitions for relocation. So here you have it written into section 10 of that statute that an evidentiary hearing or non-jury trial on a pleading seeking temporary or permanent relief filed under this section shall be accorded priority on the court's calendar. If a motion seeking a temporary relocation is filed absent good cause, the hearing must occur no later than 30 days after the motion for a temporary relocation is filed. If a notice to set the matter for a non-jury trial is filed absent good cause, the non-jury trial must occur no later than 90 days after the notice is filed. So these are important dates. If you are moving on an urgent basis and you want to maintain your hearing within the 30 days, you still, I would imagine, have to make sure that the court has a copy of your motion, that you're seeking this priority under the statute. that you do have, good cause to do so on a temporary relocation. And if you're seeking a final hearing on trial, that you do so and request that it be done within the 90 days. Now, our court system often has, difficulty fitting these in, but they do usually give them that priority when you ask for it. So make sure to raise that. And if you don't, I've seen cases where it can be waived. People waited, they had filed the motion, they didn't immediately move for the hearing, they waited some time, and then all of a sudden it became important to ask for this priority. But at that point, many months had already gone by without seeking it. So the courts, I understand, do their best under the circumstances to try to fit these hearings in the time frame that's provided by statute. But I think you have to be the squeaky wheel that gets the grease in these situations. And so this provision here may help you to do that if you do so timely. Okay. So as far as practice tips are concerned, I strongly suggest, especially if you're not a lawyer and you're self-represented, that take a look at the Supreme Court of Florida's website for family law forms. It can be found at flcourts.org. It's a very handy website, and you can go through there and look for family law forms. They usually come with instructions for people who are self-represented to get a little bit of direction when putting together some of their court filings. So we've discussed at length the petition to relocate, the objection to relocation. We've discussed a written agreement where the parties do end up agreeing to the relocation and what needs to be there. But typically when you're filing a family law case, there are many other documents that need to go along with the petition or the objection. So you also want to look at filing, if it hasn't already been done, what's called a UCCJEA. It's a Uniform Child Custody Jurisdiction and Enforcement Act affidavit. It's a very important form. The court needs that to be able to take jurisdiction over minor children. So make sure that when you're filing, if you already have a divorce or paternity matter, you may have already filed this item. But if you haven't and your initial filing is that petition for relocation, then you want to make sure that it's accompanied by the proper documents. So that would be one of them. In addition, we talked about the parenting plan. You need to provide a proposal. Well, the Supreme Court of Florida has provided us with some really nice forms that you can fill out. They give you a lot of different boxes to check off. And there is something called a long distance parenting plan. So that's something, especially in cases involving a relocation, that should come into play, and usually sets out different provisions for the transportation and who's to pay the cost and how those may be allocated. So that's already usually built in to your long distance parenting plan. And most of these items that you'll see there in the parenting plan are suggestions that help you fulfill the statutory requirements that we're talking about. However, people and their children and the family is often very unique, and you can include additional provisions. You can, make provisions, especially by agreement, that may not necessarily be included in the forms. So I would say start with the forms, look at that as a guide, but that's not the end all be all of the situation. So you can continue to add to it. Again, if we're dealing with a case involving children and support may be at issue, there may be a requirement that a filing of a notice of Social Security number go into the file if it hasn't already been done. And then typically we have to update, if we haven't done it recently, our financial affidavits. So again, there's a family law financial affidavit blank form that you can find on the Supreme Court of Florida webpage. There's also something called the Certificate of Compliance with Mandatory Disclosure. So oftentimes in our family law cases, we're required to not only provide this financial affidavit, which sets out the finances for that particular party, but we also have to complete an exchange of what's called mandatory disclosure. And this can be found under, there's a form there under the Supreme Court of Florida's website, again, that lists out the different categories of financial documents that are required to be exchanged. And these are required under our Florida Family Law Rules of Procedure 12.285. And it usually asks for things like the last 3 years of tax returns, the last year of bank account statements, savings account statements, checking account, brokerage account statements, you name it. It's all listed out there for you, copies of your lease. So this is a checklist essentially that's provided, and then you certify it to indicate that you've complied with those requirements and exchange those. It's very important for people to know that the financial documents are not supposed to go into the court file. Okay, so the actual financial affidavit is filled out, that gets filed. The certificate saying that you've complied with mandatory disclosure gets filled out, and that gets filed in the court. But the actual statements, so the bank account statements, the tax returns, those items that we just talked about do not actually go into the court file. So those are exchanged privately with the other parent in the case. And it's important for people, sometimes people aren't aware of that, and they go ahead and they try to put their sensitive financial documents into the court file. So that, just want to make clear, those actual items are being exchanged privately, but this certificate saying that you've done that goes into the court file. Okay, you may also be required to do a court-approved parenting course, and there are some suggested courses for you there in the Supreme Court's webpage. And then also, as we discussed, you may need to do a child support guideline. So it's important that you have exchanged your financials with the other parent, and that you have a sense for the transportation costs that you're speaking about, whether or not those transportation costs are going to be handled outside of the child support guidelines, meaning that when a ticket is being purchased by a parent, it may be handled that way, and that can be written into the long distance parenting plan that we spoke about. Otherwise, it may be possible to factor in the transportation costs into the actual child support guidelines themselves. But one way or the other, you may be required to do a new child support guideline. So that's an important item. There are many other filings here. I can't list them all, unfortunately, but I would, again, refer you to that website. Okay. So some additional considerations here. When you're, again, looking to relocate, or you may be objecting to a relocation, does the relocation better improve the overall quality of life for the child? So we looked at that factor earlier that talks about the parent and the child. And from experience in these cases, sometimes the parent gets so fixated on their own interest, their own experience, they have to respond to the job offer right away. Sometimes they forget that this is a child-focused inquiry. At the end of the day, it's really the best interest of the child that should prevail here. So you really want to, tell this court whether it really improves the overall quality of life. And we mentioned a couple examples where perhaps the parent is looking to accept this job, but the child's about to turn 18 and wouldn't really benefit. It would go through this whole move, really just for the sake of the parent. So you really want to show, that if you're looking to relocate, maybe there's some additional benefits to the child to be in the relocated area beyond that time period. And there are a lot of considerations that, you want to put into this if you're filing the petition to, tell the court how you believe that it may improve the overall quality of life for that child. Okay. One of the considerations I would encourage you to look into is, how does the new neighborhood where you intend to relocate, or the actual new house where you intend to reside in, the new schools for the child, how do those compare with the current environment that you have for the child? So these are things you want to be as specific here as look at how many bedrooms and bathrooms you're looking to have. Does the new neighborhood, is it safe? Does it have, parks nearby? Is the school close? Does it have, bus transportation for the child to get to school? How are you going to make those arrangements? The school itself, what are the ratings for this new school compared to this prior school where the child was attending? If the child has any kind of special needs, are there programs nearby? Are those needs being met in this new area? And what kinds of unique programs do they have for a child who may be interested in something specific that may be able to benefit that particular child by this relocation? So you really want to dig into the facts and the proposed, for the proposed relocation area and how they're going to better that child's environment. Okay, another factor here is, something to take into consideration on a factor, I guess, but I think it's very helpful to consider whether you're looking to move to an area where you have extended family members and a strong support system. So you're never going to replace the other parent. You have to shy away from, any kind of arguments where the grandparents or some other family member are going to be seen as, in some kind of superior position to the other parent. It's not to replace the other parent by any means, but you want to look into this to see whether or not you have support. We often say it takes a village to raise children. So are there people in this new area who can help out with childcare, who can really, be there for the child? Does the child have cousins who the child would be close in age to in this new area? Aunts and uncles, grandparents who can help really enrich the life of the child in this new area. So if not, you really have to consider what are going to be the new, regardless, you have to consider what are going to be the new child care arrangements. So a child, in a new area, you may have to consider a new aftercare arrangement, or a new babysitting arrangement. And so you definitely want to take that into consideration when, I would say early on, when you're looking to file for relocation. On the other side of this, if there are many family members in the area, of course, the other non-relocating parent, along with a strong support system in the current area, that may be a basis for you to strongly object to somebody seeking to remove a child from, the family that they've been close with, right? So maybe they have grandparents, cousins, aunts, uncles, all the above, in this area. So that's something that you want to consider. And maybe they have a wonderful school system where they've been thriving here in a wonderful neighborhood with friends in the neighborhood and activities. And maybe they've been doing those activities for many years with the same kids. So those, on the other side may help you to object to a proposed relocation. Okay. So, sometimes there are unique opportunities in other areas. There are cases where children have special interests. I've seen cases where a child had an interest in engineering and there was a wonderful engineering program in a different area that the child really wanted to take part in. And so that may be, something you may want to sell the court on if you're looking to relocate and the child is very excited for this opportunity to be part of some program that's unique to that area. And on the other hand, again, there may be opportunities that the child has enjoyed. So we don't want to, to use an old expression, throw the baby out with the bathwater. If the current situation works and the child's really thriving and there are some really wonderful programs the child's been involved with in the current area, you don't want to throw that all away in favor of some some idea of an opportunity that doesn't maybe have a track record, and you can say, there's no history here, but there is, a history in the current environment. So some things to take into consideration when you're petitioning or objecting to relocation. So I think that is really it in terms of going through the statute. Like I said, it's highly technical. You want to make sure that you cross all your T's, dot all your I's, that you've complied. And if you have to read the statute over and over again, please do, because each section has, unique points. And there are many, many interesting relocation cases. They're not easy. You really do have to, I would say, give it your all. If you're looking to relocate, it's not an easy ask to make of the court. And again, if you're objecting to a relocation, the court really has to balance the interests and weigh that. And so you really want to bring, all of your facts and concerns related to the objection. So relocations are very, very specific types of cases for the courts to consider, and they're often sometimes the hardest cases to decide whether or not to permit a child to move away from a parent. So take it very seriously, do the work, I think that sums it up. Thank you very much for having me here today.
Well, thank you so much for all that information. I took lots of notes because I know that I don't know if you know this, but here at Legal Aid, I do advice and counsel. So I do actually counsel people who are pro se on how to do them on their own. I did not realize that there was the timing statute. What would you recommend for, these pro se individuals that I counsel, for them to get when they do have these urgencies, like they have to respond to a job offer, or in some cases I've dealt with people who are, close to getting eviction and they have nowhere else to go. What would you recommend once they file their petition, like emailing the case manager, emailing the judge's office, something like that, to get their matter expedited? What would you recommend in those cases?
Right. Yeah, it can be very time sensitive for a lot of these relocation cases. So absolutely, you want to make sure that you've complied fully with the statute, going through all of the, requirements there, and that you've met all of them as quickly as possible in terms of filing the petition the correct way. I think that you have the motion for temporary relocation, which affords you that priority to be heard within the 30 days. And if you're really under some urgent, circumstances, then my suggestion would be to contact the judicial assistant for the judge and make it known what are the circumstances. I would ask for the soonest available date. I would make sure to remind the court gently of the priority that's afforded to these types of cases. And I would also, just explain the circumstances, be willing to take a case if another case, settles out and the court finds itself having some time, to ask the judicial assistant to keep you in mind so that you can maybe get on the calendar even sooner. If that were to happen, there's some sort of vacancy and you can get in for hearing. So those would be my suggestions.
Okay. And the other question I had, and this is just personal me, but in cases where domestic violence has been an issue, and so is there anything under the relocation statute that allows for emergency jurisdiction for this person to move without notice by any chance?
Right. That's a really good question. So actually, I don't know, under this particular statute is 61.13001. that there's an emergency jurisdiction necessarily, but you would find that probably under the domestic violence injunction statute. So you'd be looking at, chapter 742, I believe it is, 741, 742, and you'd be looking at domestic violence because usually there's provisions there for people who relocate due to domestic violence situations. And I believe, may not even be considered a relocation because, again, relocation really refers to more than 60 consecutive days, and it's not intended to be temporary. So oftentimes when people are fleeing a domestic violence situation, it's usually, and it doesn't have to be, but it usually is very sudden, and usually it's not with the intention of this is going to be my permanent move. So it may afford them some more flexibility to say this isn't a relocation per se, but if they do move, from their last residence, and then they're, having to seek some sort of protection, I think that they want to file for, whatever it is, the petition for the injunction for protection against domestic violence, make sure that they've informed the court, they've put that filing out there, and then if they do file a petition for relocation, that they may want to reference that there's a related case going on for the domestic violence, so that the court's aware and taking that into consideration, so that it's not seen as, they relocated without permission or without leave of court, right? So I think that they, would want to make sure that that's well known and understood.
Okay. All right. Well, thank you so much for your time. We are very grateful that you came and presented on this most important topic. For those attorneys out there that are here for the CLE credit, the reference number is 2505516N. Again, 2505516N. And we were approved for 1 CLE credit for listening in on this learning topic. So I think that's it. Thank you so much for being here again.
Thank you so much again for